Court has been advised that we have a verdict. Are we ready for the jury?
Yes, sir.
All right, Mr. Mullins, go get the jury. You may be seated. Who has been selected as the foreperson for our jury?
I have.
All right, ma'am, has the jury reached a verdict in the case?
We have.
Without disclosing the nature of the verdict, were you able to follow, was everybody able to follow my instructions while you were deliberating?
Yes.
Yes, sir.
Were you able to remain free from any outside contact, communication, or influence during the deliberation process?
Yes, sir.
All right, please hand the verdict forms to Mr. Mullins. In advance of the reading of the verdict, I want to thank each of you for your service. After this, you will be discharged from your service. You'll be returned to the jury room, reunited with your electronic devices. I have a couple of minutes that I would like to talk to you, and then we will get you on your way. You will be able to speak with anybody about the case that you would like, but you are not required to do so. Whether you decide to speak to anybody is a matter of your own free choice. Would the defendant please rise? With regard to count one, we, the jury in the above captioned case, find the defendant, Skylar Richardson, not guilty of the offense of aggravated murder, and there appear to be 12 jury signatures affixed. Verdict form 2, involuntary manslaughter. We, the jury in the above captioned case, do hereby find the defendant, Skylar Richardson, not guilty of the offense of involuntary manslaughter. Count 3, child endangerment. We, the jury, find the defendant, Skylar Richardson, not guilty of child endangerment. It does say we further find the defendant did not cause serious physical harm to the alleged victim, but that finding is not necessary as a matter of law. Verdict form number 4, we, the jury in the above captioned case, find the defendant, Skylar Richardson, guilty of the offense of abuse of a corpse. Ladies and gentlemen, are those the verdicts of the jury?
Yes, sir.
You may be seated. All right, again, you are now discharged from all your service. Does either side wish to have the jury polled?
No, Your Honor. No, Your Honor.
All right, ladies and gentlemen, you will now be returned to the jury room. Thank you for your service. Mr. Mullins is going to give you back your phones and such, and I will see you in a couple of minutes. You may be seated. We are on the record outside the presence of the jury. Anything additional from the state?
No, Your Honor.
Anything additional from the defense?
No, Judge.
All right, the court will order that the verdict forms be filed. I will draft an entry accepting the verdict forms. I'm going to set this matter for sentencing tomorrow at 11 o'clock. I will order a pre-sentence investigation between now and then. So court services will conduct a pre-sentence investigation. They can tell me that they can get that done between now and tomorrow. Bail for the defendant is hereby revoked pending sentencing. We'll see everybody tomorrow at 11 o'clock. That's all.
All right. Court's in recess.
even though the maximum for this offense is 12 months in prison, the maximum that I can sentence you today is to 6 months of local incarceration. That means in the county jail. We have 7 days of jail time credit. I think one thing it's important to point out, Ms. Richardson, before we get started with the trial, or with the sentencing hearing in this case, is that in the entire time that this case was pending, back when it started, I set a bond, and that you've been sleeping at home while this trial has been going on, and you've been out and about. I know that there was some angst about that, but the reason I do set a reasonable bail in a case is because you're presumed to be innocent. That means that you haven't been convicted of anything, and you have the right to a reasonable bail. Yesterday, after you were convicted of the felony, even being a low-level felony that it was, you're no longer presumed to be innocent. And while it's fair that you would be out in the community while we figure out what's going on with the trial, when you no longer have that presumption of innocence, it's fair that you be in jail until we figure that out, which is why we are here today. I think one other point that bears mentioning at this point is, I'm not sure it's really relevant to what we have going today, but this has been an extraordinarily high-profile case, and lots of people in the community are talking about this case, whether it be in their workplace, posting about it on the internet. It seems like everybody has an opinion on the case. I think about everybody in Warren County has the Court TV app on their phone now, which means that everybody knows about this case. Prior to us beginning this case, the court undertook a cooperative effort with our friends in the media to make sure that the trial of this case, not all the gossip, not all the press conferences and what goes on in the hallway, but the actual presentation of the evidence and the arguments of the lawyers was available for everybody to see. I allowed the cameras in the courtroom, even the one behind me that I was not very thrilled about, so that people would have the opportunity to see this. Our IT people beefed up our bandwidth. We even drilled a hole in the side of the building so that we could run the wires out to the van. The reason that I say this is I think there is some value in the community having the opportunity to actually watch this trial. I only have 40-some seats in the courtroom, so it's out there. So if people want to know what happened in the trial, they can go watch for themselves. They don't have to rely on what somebody posts about it or what somebody tweets about it. They can see the actual evidence that was presented. One of the reasons that I did this is so that the community, whether they agreed with the verdict or not, would have confidence in the way that decision was reached. So if somebody comes up to you and talks about how we have a baby killer that got off in Warren County, or we have an innocent person who was convicted and didn't do anything wrong, we can direct them to the actual evidence so that maybe you can get a better idea of whether or not they have an accurate opinion of whether justice was served. Mr. Knippen, on behalf of the state.
Your Honor, the court is obviously very aware of the facts in this case, and it is clear from the defendant's actions that she never intended for anyone to even know that her daughter existed or that the skeletal remains would ever be discovered. But for her being confronted by her doctors at Hilltop, that child would still be buried in the backyard of their home without anyone knowing. And as a result of her conduct, the state would ask that you impose the 6 months of local jail time as part of the community control sanctions that the court is required to impose as a matter of law. Thank you.
Officer Bencher, anything from probation?
Your Honor, the probation department is recommending some local jail time, compliance with mental health treatment, 100 hours of community service, corrective thinking class, and to maintain school or full-time employment.
Sure. Anything on behalf of the defense?
Yes, Your Honor. We would like for Mr. Richardson to address the court.
Do you want to up at the podium?
Yeah.
Skylar?
Yeah, let's go up.
You can remain at council table. You can come to the podium. It doesn't matter to me.
But I want Mr. Richardson to be comfortable when he speaks.
Go ahead, Mr. Richardson.
Your Honor, this has been a difficult ordeal for the entire family, including the defendant's side or the prosecution's side. My daughter is suffering from an eating disorder, and we're concerned for her health. Anything you can do to help us get her home soon so we can take care of her, we greatly appreciate it. That's all I have.
Judge,
Mr. Rickers?
thank you. Judge, as the court's well aware, Skylar's been under pretrial supervision for the last over 2 years. She was on house arrest for a year, where she could not leave the confines of her home. Subsequently, I believe the court gave her a little more freedom with the curfew. It's my understanding she's been totally compliant with pretrial services. There's nothing to indicate whatsoever that she was breaking any of the rules or doing anything other than what the court expected of her. I think the court is well aware, at least I hope the court is well aware, that Skylar does have a severe eating disorder. She is down, I just learned, she's down to 89 pounds. 89 pounds. She's losing her hair. During the course of our representing Skylar, I had recommended to her and her mother that she needs to see her pediatrician just to make sure that her potassium levels, etc., were okay, because quite frankly, we were all afraid for her well-being. It turned out that Skylar and her mother went to the pediatrician, who immediately sent her to the emergency room, where she did receive treatment because of her low potassium levels, etc., which I believe results from this lack of eating nutrients. I would hope that the fact that she has lived this nightmare and lived under this cloud and lived under with the knowledge that she could go to prison for the rest of her life, and what kind of bearing that had on her, the court would take into consideration. Thank you.
Ms. Richardson, you get the last word in all of this. Is there anything that you want to tell me before I impose a sentence?
Thank you, Your Honor. I would do anything and above that you ask, and I understand. And I just wanted to say how sorry I was. I can sometimes be selfish, but I would like to think that I've become better in the knowledge that I've upset everyone and hurt so many people with what I've done. And I'm forever sorry, and I'm so sorry. I'm really, really sorry, and I understand. And thank you.
Ms. Richardson, we've been living with this case now for over 2 years. Actually, part of it is still in the Supreme Court, even as we speak right now. And I've always sort of thought of this case, Ms. Richardson, as a story of two little girls, Skylar Richardson and Annabelle Richardson. And, you know, I have a daughter about your age, Ms. Richardson, and I have a granddaughter about the age that Annabelle would be right now. The jury found that the state did not prove that you were guilty of killing your baby, either intentionally by way of aggravated murder or recklessly by the involuntary manslaughter. But in all of this mess that we have with this case, I think what often gets overlooked, Ms. Richardson, is just how precious life is. Your life, Annabelle's life is precious, and it should be protected, and it should be guarded in all respects. And I have reviewed all of the expert reports in this case. I listened to the expert's testimony. I firmly believe, Ms. Richardson, in fact, I know in my heart that if you would have made different decisions in this case, Annabelle would be here today. And I know that might be difficult for you to hear. Some people are inclined to think to themselves, You know, this is America. We kill unborn babies every day. But I don't look at it that way, Ms. Richardson. And the law does not allow me to consider the acts that you took prior to giving birth. But I think that your choices before birth, during birth, and after show a grotesque disregard for life. And I think when I look at this case, that to me is what offends the community sensibilities. But because of policy decisions that are beyond my purview, the jury was not permitted to consider those things, and neither am I. So I don't hold those things against you in the sentencing. I find that you are amenable to community control. It's a mandatory community control case. I'm going to place you on 3 years of basic supervision. I'm going to impose upon you the standard rules of community control, and I'm going to delegate to your officer the ability to make special or additional conditions as they see fit. I'm going to order as a term of your community control that you spend 7 days in the county jail. I'm going to credit you the 7 days that you have already done, which means that you are going to be going home today. Your stated prison term is going to be 12 months in prison. I'm not sending you to prison today, but if you violate the terms of community control, I can impose up to the maximum penalty in this case. This includes an optional period of post-release control. If I send you to prison, the adult parole authority then has the option but not the requirement to supervise you for up to 3 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the sentence that you would receive for the new felony. None of this prison business matters to you at all as long as you don't violate the terms of community control. Officer Bittinger has made some excellent recommendations in this case about things that you should do. I'm not going to follow any of those recommendations because I think that it is sufficient for me to supervise you, and as long as you don't violate the terms of community control, our standard rules, hopefully we won't have any more issues. I'm not going to impose a fine in the case. I am going to impose the costs upon you. Is there anything else? You can be seated if you want.
Thank you.
On behalf of the state?
No, Your Honor. Your Honor, will the ankle monitor be removed?
Yes. I mean,
Thank
she
you.
shouldn't have it on now, right?
I
I mean, she
don't.
came over from the jail.
I didn't know that. Thank you, Judge.
All right, we have one additional matter that I think needs some attention, is that the remains of Annabelle are in the custody of the Warren County Sheriff pursuant to the search warrants that were executed in this case. Mr. Knipp and Ms. Kraft, does the state have a position on this?
Your Honor, it's my understanding that both families are interested in the skeletal remains of the baby in this case, and I don't know how legally that is to be determined as to who should get the remains.
I mean, they were seized as evidence in this case pursuant to the search warrants issued in this case, right?
Yes, Your Honor.
I mean, there's nobody that knows more about it or has a better position to make that decision than me, right?
I don't know the legality of that, Your Honor. I don't.
Okay. All right. Does the defense have a position in this?
Your Honor, we have no objection to you making the decision on this. Mr. Richardson and the Richardson family had spoken with the Warren County Sheriff's Office between July 14th and July 20th. They had made plans now for more than 2 years to have a proper burial, proper memorial service. We've asked them, even without having Annabelle back, we've asked them to hold off on doing balloon releases and a lot of things that they've wanted to do because of the pending case. But the family has a burial plot, as I believe you saw, even though it wasn't admitted into evidence. And the Richardson family would like to bring closure for Annabelle and give her an eternal resting place. So we would request that you give the Richardson family Annabelle.
Mr. Richardson?
Yes, sir.
Do I have your word that those remains are going to be buried properly and that there is going to be access by the Johnson family so that they can pay their respects?
Absolutely, sir.
All right, I am going to order that the remains of Annabelle be released to the Richardson family within 7 days of the time of the sentencing entry, which will likely be today. Ms. Johnson, if the remains are not buried in a way that is appropriate and that you do not have access to pay your respects, please get in touch with my probation department or through the prosecutor's office and let me know that. I'm going to hold Mr. Richardson to the promise that he made here today, and if he does not keep that promise, he will answer to me in that regard. Mr. Richardson, once the arrangements have been made, please forward a copy or an email is fine, Mr. Rickers, as to what has happened, forward it to the victim's advocate, the prosecutor's office, and probation. Is there anything else we need to do today?
No, Your Honor. No, Your Honor.
All right, finally, Ms. Richardson, you have the right to appeal this case to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you without charge. Good luck to you. We are in recess.
Thank you, Your Honor.
All right. Yes, everybody, stay seated just for a moment, please.